Hello, everybody. My name is TJ Scott. I'm an estate planning attorney with the law office of Timothy J. Scott. What does an estate planning attorney do? What does that mean? We're going to talk about that here. I am located in Minnesota. I'm in Bloomington, Minnesota right now, just outside of Minneapolis. My office is on France and 494, so kind of in a major corridor there in the Bell Bank building. So hopefully some of you will have the opportunity to come and visit me and see me there. We have a ton that we're going to go through today. This is really a doozy of a topic, a checklist to get all your estate planning done in 2026. It's not going to be easy. It's going to take attention. It's going to take time. And so I am here to share the information with you, but it's a lot of information. So please dial in with me, turn off any distractions that might pull you away. Give yourself this time. You have registered for this webinar. You've said, this is something that's been on my mind. It's something that I know that I need to learn about. Give yourself this time. You're here with me now. And I always say your future self is going to be glad that you took the time to educate yourself. And please stay with me through to the end. This is an overwhelming topic. Again, how do you complete your estate plan in 2026? There are a lot of moving pieces, there are a lot of moving parts, but I want you to stay with me because I can distill those complicated parts down into one action item. And that's what I'm going to tell you about right at the end of our presentation here today. I want you to stay with me because I want to offer you a free virtual one-on-one meeting to continue our conversation and to make it specific to your life and to your fact pattern so that you can know exactly what you need to do in order to protect the people that you love and how you can protect the things and people that you love. Plus, I want to give you a bonus gift to make it even easier to get a personalized and tailored estate plan in place. And again, I can make this easy. I can take this burden off your shoulders. I can take it off your mind. These are a couple of the things that I've heard from people who are here in attendance today. Things that people are hoping to learn, that they're hoping that I'm going to address. Can I do my estate plan by myself? Is there a DIY option for estate planning? And I'm going to speak specifically to that today. How do I choose my fiduciaries? How do I choose my trustees or my healthcare agent or my financial power of attorney? I'm going to speak to that, and I'm going to speak to kind of the process that we use to make those decisions. How can I protect my business? This is an important thing. If you own a business, you want to make sure that it's protected. You want to make sure that it's going to the people that you want to have receive. What do I do with my IRA or my Roth IRA? How do I handle that? How do I set up beneficiaries on things like my life insurance, my retirement accounts? Those ones make it pretty easy, but what about things like bank accounts or investment accounts or stock or treasury bonds or what about things like bank accounts? How do I take care of these things? We're going to talk about a lot of these things today, and we're going to talk about them in the order that I really recommend that you tackle things. If you have specific questions or if one of these resonates with you and you want to make sure that I'm spending more time and focusing on it, I encourage you to share with me either in the chat function or in the Q&A box so that we give it the attention and give it the time that it really deserves here tonight. I want you to know that whatever and wherever you're coming to this from, you are in the right place here. If you have someone or something that you care about and you want to protect, you're in the right place here tonight. That's exactly what we're going to be talking about, is how can you make sure the people that you love and the things that you have are protected. And we're going to talk about online wills and DIY wills. And we're going to talk about when it works and when it isn't the best option. We're going to talk about the cost of estate planning, because I know that makes a lot of people nervous. I know it's something that's on our mind. But I know that this in general is something that makes us uneasy. The reality check is this isn't really about us. Estate planning isn't really about the people who are here today. It's about the people that we love, that we're going to eventually have to leave behind. And estate planning is a gift that we can give them to make sure that they're well cared for, that what we want to have happen in their lives is what happens in their lives. So Here's our checklist. This is where we're going to start, or this is the process that we're going to go through together. And as you can see, there are lots of things on here, and this is just what I think that I can address, what I think I can get to in an hour's time. A lot of information, and we're going to go through it really quickly, talking about things like guardianship for minor kids. That's the number one priority. If you have kids under the age of 18, you need to get those guardians in place for those minor children. And I'm going to go ahead and, if I can, launch a poll here to ask, who of you have minor children? If you don't mind sharing with me, I would really appreciate it. It helps me to know where to focus my attention and how quickly to go through some of those provisions. But we're also going to talk about incapacity. A lot of times people think with estate planning that it's just about planning for after I die. In reality, there are times during your lifetime where your estate plan may kick in and may have an effect that's really important for you and really important for the people that you love. And that involves things like who can make healthcare decisions for you, who can make financial decisions for you if you can't make them for yourself. Thanks everybody for sharing. That's a really great response to the poll. I really appreciate that. Thank you. We're going to talk about how you can get financially organized and why that's so important for the people that you love if something should happen to you. We're going to talk about deciding who receives and what's the default here in the state of Minnesota. How can you take control and make sure that your wishes and not the state of Minnesota's wishes take precedence over who receives from your estate? We're going to talk about avoiding court and conflict. And I would say this is the number one thing that I hear from clients who come in and talk to me. One of the things that I hear is, this has been a weight on my shoulders for a really long time. The other thing that I hear is, I just want things to be easy for my family. I just want it to be simple. Avoiding court and conflict is the way to make it easy. It's the way to make it simple. And we make the whole process easy because we have such a great process of our own in place. And we're going to talk a little bit about some advanced topics, things like avoiding estate taxes. Honestly, if avoiding estate taxes is a priority for you, you really ought to be hiring an attorney to do your estate plan. That's never something that you should be trying to DIY a solution to avoid estate taxes, because the laws around estate taxes are complicated, they're thorny, and we're going to talk about when you should and when you shouldn't be worried about estate taxes towards the end of our presentation here. But before we get into that, I want to tell you a little bit about myself. Again, my name is TJ Scott. I'm married. I have 5 kids. We live in Bloomington, Minnesota, and we homeschool those kids. At least the 3 that are able to be in school right now. I graduated from the University of St. Thomas School of Law in 2012, and I worked really hard when I was there at the law school. I was on the law review and I graduated magna cum laude, things that typically set you up for a job in big law, working downtown, 80 or 100 hours a week. But something amazing happened to me the day after I commenced from law school, and that's that my oldest was born. My son, Ben, was born. And being in the hospital room with my wife and with Ben really clarified my wishes for me. I knew that I wanted to work in the law in an area that served people, that took care of people, but also allowed me to spend time with my family. And I was really lucky. I found an estate planning law firm where I learned how to write great documents from somebody who had been practicing estate planning for something like 35 years. She was kind of at the end of her career and I was just starting my career. And so I was able to learn how to write really good documents. I also learned from her that estate planning takes a lifetime of guidance. It takes a counselor to walk with you and to help you and to make sure that your plan is going to work the way that you want it to work when you need it to. So before we get into our checklist, we should take a step back and we should answer kind of a fundamental question here. What is an estate plan? And a lot of times when I ask this, people think, an estate plan is a will, right? Kind of. I would say an estate plan is really an umbrella term. It's a plan for your person, your assets, and those you care for in the case you become incapacitated or for when you pass away, because that's the reality. We're all going to die someday. We know that. Some of us may become incapacitated, through something like dementia or through something like a car accident that leaves us in a coma before we die. It's an unfortunate reality, but we don't have to be scared of it. We should be empowered by that knowledge. We should be empowered by educating ourselves and taking control so that if something happens to us, we know our loved ones are going to be protected. So that's an estate plan. We want to think about a whole host of things. Certainly after we die, who's going to receive our assets? That's an important thing. But also important things are before we die, if we become incapacitated, are the right people going to make decisions? Are they going to know what to do? I have one other poll here. I think this is the last poll that I have, and it just asks, do you have an estate plan? Based on that definition, a plan for your person, your things, the people that you care about, if you become incapacitated or for when you pass away, do you have an estate plan? And I'm seeing kind of a smattering. I'm seeing some people yes, some people no. Sometimes we have an estate plan in place, but it's maybe not up to snuff, or it's not up to the quality that we want it to be, or maybe it's old and we know that we need to update it. So I'm seeing kind of a mix of responses here. But again, I really appreciate you weighing in here. The reality is, and I'm going to go ahead and end the poll here, we have pretty on target numbers based on what the statistics are here in America. In America, something like 68% of Americans have not written a will, and here you can see that our numbers here are pretty on pace for that. The reality is, whether or not we've written an estate plan, there is an estate plan out there for us that the state of Minnesota creates a default estate plan. And typically that default estate plan means we're going to go to court. The court is going to decide, based on the statutes, based on the laws in place here in Minnesota, what's going to happen with your assets, what's going to happen with your kids, what's going to happen regarding your healthcare or financial decision makers. But it doesn't have to be that way. For all of these things, we can take control, and we take control by drafting estate planning documents using estate planning tools like trusts and wills, healthcare directives, powers of attorney, memorial instructions, all these different things that we're going to talk about more throughout the course of our presentation here tonight. So the first thing that you should be thinking about, if you don't have an estate plan in place and you have kids under the age of 18, is long-term guardianship. It is crucial to get this in place, because if you haven't made a plan for the kids, then a judge is going to make the plan for you. And unfortunately, if that means that the judge thinks Uncle Larry is the best person to take the kids, even if you know Uncle Larry is the wrong person to have them, or Aunt Nancy gets to have the kids even though you know Aunt Nancy is the wrong person, I shouldn't use specific names here, and so my apologies if anyone is upset hearing their name here tonight. It's not my intention at all. But whatever the case is, we don't want a judge to decide what's going to happen with the kids. You are the parent, and you should have the right to make the decision about what's going to happen. This is the rubric that a judge uses. What is in the best interests of a child? And they evaluate it in terms of all this information that they're going to go through. But it doesn't have to be that way. A parent can name guardians, can nominate guardians in a document, and the judge is going to give that first effect if something happens to the kids. All right, not everybody has minor kids, but everybody has a need to create some guidance in their healthcare decisions. If you haven't provided guidance to your family, if you haven't provided guidance in some kind of legal document about who you want making healthcare decisions for you, then there's a process for that. And the process through the court is called guardianship of the person. And you may remember a case like this. This young woman, her name is Terry Schiavo, and Terry Schiavo suffered a cardiac event when she was young, which left her in a vegetative state. She was on a feeding tube, and her husband wanted to remove that feeding tube. Her parents disagreed. Her parents wanted to keep the feeding tube in and to preserve Terry's life. Through a series of court cases, it was eventually decided that the husband had the right to say, and the feeding tube was removed, and Terry passed away about 2 weeks after that decision was made. But it took years of court cases and court battles and conflict in the family in order to make that determination, and it didn't have to be that way. There is a way that you can decide who can make healthcare decisions for you and the types of healthcare decisions that you want made. And you can do that in a document called a healthcare directive. And there are different forms that float out there. There's a form, in fact, that Minnesota puts out. You can find it on the Minnesota Attorney General website. But if you look at that document, if you download that document, you'll see it asks for long, lengthy descriptions about questions like, this is what I believe about my healthcare, or this is what I think is valuable about my life. And they're very nice questions. And if you can spend the 8 to 10 to 12 hours in order to write in essay form your responses to those, I'm sure it could be very helpful in guiding your family down the road. But the reality is, for most of us, it's not tenable. Adding an extra 8 to 10 hours in order to prepare a healthcare directive just isn't really an option for most of us. You want to make sure that you're using a document that's good, that provides enough guidance, and we do that. We have a fantastic healthcare directive that will allow you to make those decisions in the course of about 5 to 10 minutes by really boiling it down to some examples and asking your questions in the context of those examples. If you're incapacitated and you haven't named somebody to make financial decisions for you, there's another process that goes through the court called conservatorship of the estate. And you may be familiar with this. We all know a young woman, Britney Spears, who had her estate under a conservatorship during her lifetime. I think she's out from under that now. But a conservatorship means that a judge is going to appoint somebody to make decisions about how your assets are used and ask for accountings from that person. It's expensive. Oftentimes you have to hire an attorney and an accountant annually every year in order to make these reports to the court about the way that you're using the money and how things are being handled. But it doesn't have to be that way. You can decide who's going to have the right to deal with your assets, and you can give them that authority in the specific way that you want them to have it through something like a power of attorney. So we've already collected a few documents that are crucial and that we have to look at. There is guardianship nominations if you have minor kids. And that guardianship nomination form isn't really a form that's out there. It's not something that you can easily find, but it's something that you could create if you spend 3 to 4 hours reading the guardianship provisions in the code. So that's number one on the checklist. If you have minor kids, you're going to have a few hours of research, a few hours of creating a document, and a few hours of actually filling the document out. Number two, we all need to name our healthcare agent, and we need to specify the kinds of decisions that we want made. Unfortunately, it's not easy, and the forms that are out there don't necessarily make it easy. They take time and they take attention, they take interpretation that can be intimidating, unfortunately. And then a third document here, power of attorney, naming somebody who can deal with your finances, do things like move money between bank accounts, make sure that your bills get paid, make sure that your taxes get filed if you're incapacitated and you can no longer do that. These are really important, really crucial elements of your estate plan, and we haven't even gotten to your assets yet. Before we get to your assets and to who's going to receive and how they're going to receive, we have to get financially organized. And what I'm talking about when I say financially organized is we have to have some semblance. We have to pull together information about where our assets are and what it is that we own. In Minnesota, there's something like $700 million in the Minnesota Department of Unclaimed Property right now. That's money that's just sitting there that nobody has access to, nobody is able to use. And a big way that the money gets to the Minnesota Department of Unclaimed Property is that somebody passes away and their family, who comes behind them, isn't aware of all of the accounts or all of the stock or all of the life insurance policies or all of the things that that person owns. This can even extend to things like parcels of real estate that family may not be aware that somebody owns a hunting property, just hasn't been to the hunting property in a while. It's wild the number of things that end up in the Minnesota Department of Unclaimed Property. Like I say, last I checked, it's something like $700 million there. So we've got to get organized. We have to figure out a way to put that information together. Across the United States, in the departments of unclaimed property across the United States, that number is something like $58 billion with a B. $58 billion that's just sitting there, not doing anybody any good. And it's sitting there because something got missed. We weren't financially organized. Our family wasn't aware of where things were. That's not the case for my clients. My clients, we put together an inventory of their assets to make sure that everybody knows exactly what they own and where things are. And this is a sample one. You can see I filled it out with some kind of goofy information here, but you can see what that looks like in order to make sure that when something happens to a client, we know where their assets are. We're able to address it. We're able to find their assets and make sure that the people that they love are going to receive the things that they have. So this is really important, getting financially organized. And we make this easy for our clients by having them complete a form that they submit to us. It's a form that they can continually update as well as time goes on. But it's really a clarifying document that helps people see what it is they have and how they need to organize things. Who is going to receive from your estate? This is really important. And in fact, I would guess that this is probably one of the top drivers in people seeking to get an estate plan done. I want to make sure that the right people receive the assets from my estate at the right time. And this is important. Obviously, this is important. Minnesota, again, has a default. They have default recipients that they think you probably want to have receive your assets. Luckily, Minnesota is usually not too far out in who they choose. Number one, they typically say, we think that you want to provide for your spouse if something happens to you. Number two, after you've provided for your spouse, we think you probably want to provide for your kids. Or if not your kids, if your kids have predeceased, you probably want to provide for your grandkids or great-grandkids. If we can't find anybody who's lineally descended from you, again, spouse first, and then lineal descendants, things like kids, grandkids, great-grandkids, then we're going to go up a level. We're going to go up to your parents and have your parents receive first. But if not your parents, we're going to have your siblings, nieces or nephews, grandnieces or nephews. And again, if we're not finding anybody in your families, in your parents' lineage, we're actually going to go up to your grandparents' lineage and have things go through your aunts and uncles, first cousins once removed. This is how you hear those crazy stories about somebody's third uncle leaving an absolute fortune to them because the family succession just happens to work that way. Sometimes that happens, but I can tell you that third uncle probably didn't have in mind that this cousin or this nephew or niece that they had never met was going to end up receiving their entire estate. In fact, if you notice there, things that I didn't talk about being in that course of intestacy statutes include things like your church or charity, which for many of us would have a priority. And it doesn't naturally include things like giving directly to grandkids or great-grandkids which I know a lot of my clients have really enjoyed having options of providing for the education for their kids or grandkids, to make sure that that's taken care of for them. So you can take control of who is going to receive from your estate in a number of ways. A will is a great way to do that. Things like beneficiary designations, transfer on death designations. There are a lot of great ways where you can take control and decide who's going to receive from your estate. But again, it's another decision that you need to make in addition to guardianship nominations and healthcare agents and powers of attorney, organizing yourself financially, making sure that the right people are receiving, and then making sure that they're receiving in the right way. Again, the default plan for how things are going to happen here in Minnesota is court. It's just the easiest way for Minnesota to deal with it. If it's about who gets to make healthcare decisions, the process is called guardianship. If it's who gets to make financial decisions, the process is called conservatorship. And after we die, the process that our assets go through in order to get to the people that we want to receive is called probate. And with anything involving court, you can expect there to be conflict. It pits in our society, or in our legal realm, in the way that law is done here and court is done. It's an adversarial system. It pits son against daughter, arguing about whether there should be equal distributions or unequal distributions, whether mom should have a feeding tube or not have a feeding tube. Again, it's an adversarial system. It sets up one side against the other and has them argue and make their best case. But that situation, that template is just rife for conflict, and we hear that all the time. This is what probate kind of looks like, kind of feels like. It's a web. It's administrative, it's slow, it takes a really long time to get through, and there are all these fees and costs that pop up along the way. So the way that probate works is after you're gone, things get submitted to the court in the county where you are a resident. And the court's job there is to decide who is going to be the personal representative, who's going to stand in your shoes in order to administer things after you're gone, to make sure that your creditors get paid, to make sure that all of your assets, at least as best as your personal representative can do, have been collected. And finally, after those creditors have been paid, to make the distributions out to your heirs or your devotees in the way that the statutes say, or in the way that certain estate planning documents say. Probate takes a lot of time to get through. In Minnesota, it takes at least 6 to 12 months, more often something like 18 months to get through the entire process. Probate's also costly. We estimate that probate costs something like 3 to 6% of the gross value of your estate. So for example, if the only asset that you have is a house that's worth $400,000, which I understand for some of us that's a very nice house, but especially with real estate prices where they're at right now, $400,000 is becoming a more and more reasonable price that we're seeing for homes that are out there. So if you only have a home that's worth $400,000, a 3% estimate, which is again on the low end, I would say the very low end for what probate would likely cost, probate would cost at least $12,000 in order to get through the process. And that's because there are things like attorney's fees and filing fees, bond premiums, can be executors' fees, appraisal fees. Creditors obviously get their piece of the pie, but there are other things as well. In that house example, if you can't sell the house, if you still have a mortgage on the property, that mortgage needs to continue to be paid during the 6 months plus that it takes in order to get the house prepared for sale. Other things like utilities continue to need to be paid, real estate taxes, homeowners insurance, all these costs add up and make it probate a really expensive process. Probate's also public. This is the last will and testament of JFK, our president, John F. Kennedy. And it's really interesting. We can see details like who is receiving from JFK's estate. That Jackie Kennedy received $25,000 plus one half of the remainder of his estate. The other half remainder didn't go to Jackie Kennedy. It went to JFK's children and their issue, which is kind of an interesting fact that you may not have been aware of, but I was able to access because his will was public. It was made public through the probate process. The important thing to know is that court is optional. We don't have to opt in to court, and we can opt out of court by creating documents like a healthcare directive, which opts out of the guardianship process, or the power of attorney, which opts out of the conservatorship process. But unfortunately, a will does not opt out of the probate process. In fact, we have this really goofy saying in the estate planning world: where there's a will, there's a probate. And it makes me cringe a little bit when I say it, but I say it because it's memorable. Where there's a will, there's a probate. We don't want to rely on the will to decide who is receiving your assets. Otherwise, we are opting into a bad system. We are opting into the probate system. But the good news is probate is also optional. And there are great ways to avoid probate. The number one way that I see a lot of people attempt to avoid probate is with things like beneficiary designations and transfer on death deeds. And those tools have a place. There's no question. Beneficiary designations, transfer on death deeds can be really useful. And there are times and situations where, yes, those are the right tools, the right options for planning your estate, for planning to make things as easy as possible. But there are things that you can't do with beneficiary designations, and there are things that you can't do with transfer on death deeds. I once heard of an attorney who left their home to their 6 kids by transfer on death deed. And let me tell you, if you leave something to 6 kids, who are all going to share ownership in it, which is the character that a transfer on death deed gives, it's like herding cats trying to get them to decide what they're going to do. As far as I know, they're still fighting about it to this day. But it's not only those 6 kids that were listed on the transfer on death deed who get a say in whether we're selling mom and dad's house, or if Junior is moving into the house with his family, or if we're going to rent the house, or if we're going to keep it as a vacation property so we can all go home and see our hometown from time to time. It's not just that those 6 kids have to make the decision, it's that their spouses have to be involved in the decision as well. So now you're multiplying out. It's not just 6 kids, now it's 12 individuals who were trying to get together to sign documents to say, okay, we're okay with moving forward and splitting the proceeds. And there are some ways, there are some court processes in order to expedite that process. You can do what's called a forced sale, for example, but that's expensive. If you thought probate was expensive, a forced sale is much more so, and much more conflict-ridden process than even going through probate. Probate, again, though, is totally avoidable, and a great way to avoid probate is by using a tool called a revocable living trust, and by fully funding that revocable living trust. A living trust or a revocable trust is essentially this: that somebody starts with property and they entrust that property to somebody called a trustee. And they say, here's what I want you to do with that property. The trustee says, yes, I agree. I will use this property in the way that you've asked me to. During your lifetime with a revocable trust, you are the settlor who's entrusting property into the trust. You're also the trustee who's going to hold on to that property and take care of it. But when you pass away, we can have somebody else step into your shoes right away. They don't have to go and get court approval like they would from the probate court. They can just immediately access those assets, and they can resolve your estate and resolve the property in your estate within about a month in the privacy of your attorney's office. It's fantastic, and it's really easy. Much easier and much more private than the probate process. But this transition is important. We want to make sure that we are fully funding that trust either during your lifetime or through beneficiary designations after you pass away. The trust is going to give us a lot more options and a lot more choice in the way that we handle things. What happens if one of the kids predecease? Well, if that child is listed on something like a transfer on death deed, we may have a mess on our hands in trying to figure out how that house is now going to go now that one of the grantee beneficiaries on the transfer on death deed has passed away. With a trust, we can provide exact details about how we want that to be handled. Maybe we want the assets instead to go to their kids, our grandkids, or maybe they're married and we really like our daughter-in-law or son-in-law and we want that daughter-in-law or son-in-law to be able to receive the assets. Or maybe we just want the assets to go to the other kids. Or maybe we want that share to go to charity now that that person can't receive it. Whatever the case, we have the flexibility using a revocable living trust to make those determinations. And that can't be said for something like a transfer on death deed or for things like beneficiary designations. They're very one-tracked, that if things go the way that you envision them going, great, it's going to happen. But if things veer off that track at all, we start to get into a mess. Whereas with a revocable living trust, we can detail exactly how we want to handle it. Should you be worried about estate taxes? Maybe. But I would say estate taxes and estate tax planning, as well as things like nursing home planning, are probably one of the last things that you should focus on. There's a little bit of an error here on this slide. In fact, now that we have ticked over into 2026, the federal exemption amount is no longer $13.99 million. No, the new exemption amount is $15 million. And that exemption is portable, meaning that if you're married, you get to double that number. The real exemption amount then is $30 million. And that's very good because the federal estate tax rate is really high. The federal estate tax rate ranges from 18% up to 40%. Imagine losing 40%, 40 cents on the dollar for everything that you're trying to transfer to your beneficiaries, to your heirs. That's the reality with the federal estate tax. The Minnesota estate tax rate isn't as bad, but the exemption here in Minnesota is much lower. The exemption is only $3 million. And unfortunately, here in Minnesota, we don't have portability for that exemption amount, meaning we don't get to automatically double that number. We have to do some planning if we want a full $6 million exemption, but it is possible to preserve a deceased spouse's $3 million with proper planning. We have talked about a lot of things, and I've gone through it very fast. I haven't seen any questions come in. I must have been talking very fast and hopefully very cogently and understandably about the things that we were addressing here. Now is a good time, if you have questions, to start to bring those questions to me, and I'll start to address them here in just a minute. But you probably are asking yourself, am I sure that this is something I can take on? I know that I need to get something done. I know that I need to name somebody to make healthcare decisions for me, or I know that I need to make sure I have a financial decision maker who can step into my shoes if I become incapacitated. Or maybe it's, I know that I'm not terribly financially organized, and the thought of losing that certificate of deposit that I opened, 3 years ago at a bank that my family doesn't know about really rubs me the wrong way. The idea that $6,000 or $8,000 isn't going to go to my kids when something happens to me, that really rubs me the wrong way. And I know that I need to get financially organized to make sure that that doesn't happen. Or maybe you're thinking about, the state's plan doesn't work for me. I don't want everything to go to my spouse, or I don't want everything to go to my kids. Or it doesn't make sense for my parents to receive my assets at this point, or my brother's been a jerk to me my entire life. Why would I want my brother to receive the assets that I've worked so hard for? Choosing who receives your assets is important, and you want to make sure that you get it right. And choosing how those things come to be, how everything gets pulled together is also important, because that's where court and conflict in the family comes into play. That's where we can make it easy for your family. So, can you DIY your estate plan? Be careful. Be really careful. I have a couple of stories or one story in particular that I really like to share with us. That it was a few years ago, and I was going to be taking my son fishing, and I had ordered new fishing poles, fishing lines in order to put that fishing line on the reel. It came without any fishing line on it, which I was a little surprised about, but that's okay. We ordered some fishing line, and I set everything up down in the basement and started winding the fishing line onto the reel. Okay, and I don't know what I did wrong, but I went to snip the line at the end after I had wound enough line onto this reel. And all of a sudden, the fishing line started coming off of the reel, and I had this huge tangled mess of fishing line on the table in front of me. And it was a total mess. It was a disaster. That was an example of a DIY project where I failed, but it was okay because I was able to fix the problem that morning. And I was able to fix it quickly. In fact, I just snipped off the extra fishing line. I still had enough on the reel that it was fine. I was able to take my son fishing. And it cost me something, I don't know, maybe 30 cents of fishing line, but I was able to fix it. I was able to take care of it. With estate planning, you're not going to be in a position to take care of it when that happens. Unfortunately, you're going to be gone, or you're going to be incapacitated at the time that your family is dealing with it. And it's not going to be quick for them to finish, or it's not going to be quick for them to clean up or to wrap up. And it's probably going to cost a heck of a lot more than 30 cents of fishing line. I'm thinking thousands of dollars in attorney's fees, unfortunately, if there is anything that can be done in order to try and fix the process. I've heard doing your own estate plan described as trying to put together IKEA furniture without the instructions. It's very difficult. I don't recommend it. I really recommend getting some help. And so if that's the case, if you know that you are in the market, you're looking for an attorney to help you, I encourage you to plan with somebody with an experience that's going to help you. We don't operate like a typical estate planning attorney. With a typical estate planning attorney, you're going to get form documents, and they're kind of set it and forget it. You're not really sure if it's what it's supposed to do and how it's supposed to work, but at least you have signed documents, and you'll put them in the bottom of your desk and probably forget about them over the years. It's not going to keep your money out of the Minnesota Department of Unclaimed Property. It's just not something that most estate planning attorneys think about or focus on. It may avoid probate, but it may not. Honestly, a lot of estate planning attorneys benefit from having the estate go through probate down the road, because then they get to handle the probate too. And so for a lot of estate planning attorneys, you may hear, why would you write a trust? You don't need to write a trust, just write a will. And the reason is because they know that there's a probate waiting when that client passes away that they're also going to get to handle. Typical experience probably isn't going to keep the family out of conflict. Like I say, if it's not avoiding probate, if it's not avoiding those types of court situations, it's probably just not even on the estate planning attorney's awareness. It may leave assets to heirs unprotected, which is a scary thought. We don't want our heirs receiving assets outright at the age of 18. It's generally not a good thing to have happen. There are certain people who can handle it, but it's pretty rare. A typical experience is not going to provide ongoing legal guidance, because they're probably going to be charging you hourly fees for any future needs that you have. And it's going to make you really hesitant to reach out and to ask your questions. And it's probably not going to adequately protect the kids, especially, like I say, if you have those minor kids and you need those guardianship nominations in place. It's really important, and not every attorney does it the right way. And you're going to be left with this question: is my plan going to work when I need it to work? And that's not a question you should ever have after you've written an estate plan. Planning with us is a totally different experience. We charge flat fees, and you're going to choose the fee based on the package that's right for you, based on the tools that you want us to use to plan your estate. Again, it's up to you. We really give you a lot of autonomy in making that decision. Planning with us means keeping your money out of the hands of the state. We make sure to inventory your assets and provide that inventory to the people coming after you, to your agents, to your representatives, to make sure that nothing gets lost. We help protect your kids totally. Not only that long-term guardianship, but we also have ways of making sure that the kids would never have to go and stay with Child Protective Services if something happened to you. We also keep family out of court and conflict. That's really at the heart of what I founded my law firm for, was to avoid court, to avoid conflict, to keep peace and harmony in the family. At heart, I'm a peacemaker. And you don't always hear that from attorneys, but I think that's really important, and I think that's a service to my clients. Planning with me means knowing that you've made the right decisions. As you can hear, I'm passionate about educating people, and I'm passionate about helping people to understand complex things. And that is an asset, that's a tool that I bring to my conversations with clients to help them, guide them along the path to make sure that they know how to make decisions and that they're making the right ones. We also have ways of providing asset protection over inheritances to really protect the family money from outsiders, things like a divorcing spouse or creditors in bankruptcy. That's something we didn't even have time to get to today because there's just so much involved in estate planning. But planning with us also means a lifetime of guidance and protection, because we don't charge hourly fees for ongoing communication. We are always open to your emails, to your phone calls, even setting up meetings. We encourage 3-year reviews, and we offer those 3-year reviews complimentary to make sure that you have a trusted counselor for yourself and for your family when you're no longer around. And you're going to know that your plan is going to work when your family needs it to work, which is a relief. And it's really probably what you're looking for. So your 2026 checklist is here, but really it boils down to call TJ. I want to help. Please give me a call and let me help. And again, when you have to choose an attorney, you want to look for one that you know people have worked well with in the past. We have over 100 5-star reviews on Google. We have been featured as super lawyers, or I've been featured as a rising star super lawyer for a number of years, member of Wealth Council, member of Personal Family Lawyers, and I'm ready to serve you. And I want to make it really easy. I want to give you an absolutely free one-on-one meeting called the Family Wealth Planning Session, where we're going to talk about the things you have and the people that you love and how you can protect them. I've linked my calendar here in the chat, if you can find that, so that you can click on that and find my calendar and see where my availability is. And I do see some questions coming in. Yes, I'm going to cover things like how to select a trustee. Yes, I'm going to cover things like planning in one state and retiring in another. My apologies that I haven't gotten to those questions yet. I will get there, I promise you. Stay with me for just one more minute. But do click into that link and look at my calendar here as we're talking too, because I want you to get a good time, and you'll see the times are kind of select on there for what you can get. So I want to give you that free one-on-one meeting. Plus, I want to give you $250 towards the estate planning package of your choice if you just reserve your appointment before the end of the week. Again, if you click on that link, you're going to see you're probably not going to find time this week. Maybe you'll find some time next week, or certainly in February, you're going to find some time that we can have a meeting together. I just want you to get on my books by the end of the week. Again, it doesn't have to mean that we're going to have a meeting before the end of the week. It just means that you know that you have your appointment reserved by the end of the day Saturday. That's what that means. So I encourage you, click through, grab some time right now. even if we have to reschedule in the future, even if we have to adjust for a spouse or something like that, grab some time so that you know that you have it reserved and you know that you're taking the next best step here. Okay, so let me answer some of these questions that have come in. Again, thank you for your patience with me here. I have someone asking, we do not have a family member to be an executor. How can we assign, who can we assign or who can be the executor when we both pass? And that's a really good question. You can look to other people. It doesn't have to be a family member. You can look to friends. You can look to acquaintances. You can look to people that you trust, coworkers, bosses in business, that type of a thing. So those are options. But there are also professional fiduciaries who can be helpful as well. And we work with some professional fiduciaries that we can recommend. And they do charge a fee for the work that they do, but they're also exceptional at the work that they do and very efficient and able to get through it very quickly and take care and do it in a really good way. So I think that might be a good fit for you, but I encourage you to schedule some time with me so that we can talk about it in a little bit more detail. Really quickly, I do see someone who's asking, can you help clients in Ontario, Canada? Unfortunately, we don't serve clients outside of the continental United States, and typically we only serve clients here in Minnesota as well. So I really apologize that I don't think that I can be helpful to you if you're in Ontario, Canada. How do you properly fund a revocable trust? For example, if you have a paid off home? That's a great question. Funding a trust with something like a home involves transferring that home into the name of your trust. Typically, we do that during your lifetime. Sometimes clients will do it by something like a transfer on, or sometimes lawyers will do it using something like a transfer on death deed, but my recommendation is to transfer it during your lifetime. And the reason that I make that recommendation is if your successor trustee needs to do something during your life, if you become incapacitated and you need that successor trustee to do something like prepare the house for sale, having it already in the revocable trust is going to make their job much easier than if it's not. And even if your home isn't paid off, even if you still have a mortgage on your home, you can still transfer it to a revocable trust. There's a special law called the Garn-St-Germain Act that says mortgage companies can't accelerate a mortgage or exercise a due on sale clause just because you've made a transfer into a revocable trust, excuse me. And so there's a great law that we can use in order to get your home, to enable us to transfer your home into a revocable trust. Next question, if we live in one state and plan to retire in another, can the trust be written so an update isn't required? That's a really good question. Here's what I typically give as guidance to this question. Number one, we often, almost always, have reciprocity with things like estate planning documents between states. That means if you write an estate plan in Minnesota and you move to Wisconsin, that Minnesota estate plan would still be enforceable, would still take effect if something happened to you. And that's good news. We want that reciprocity. But the reality is, if you're moving to certain states, from certain states to certain states, it probably makes sense to have things reviewed. The Minnesota to Wisconsin example is a good one. In Minnesota, we have an estate tax. In Wisconsin, there is no state estate tax. So we're only worried about the federal estate tax. And it changes the way that we do planning if we are writing an estate plan to plan for that estate tax here in Minnesota, but we wouldn't need to worry about the estate tax in Wisconsin. So my recommendation is don't wait on it. You haven't had an estate plan in place. And I want you to have that closure. I want you to have that security of knowing that things are going to be taken care of if something happens to you. And if you eventually move, we will cross that bridge when we get there. One thing that I've done in the past is I've had clients move to other states, and I've arranged with co-counsel in that state to review their estate plan, make recommendations, and I've been able to continue working with those clients to update their estate plan to match the laws in their new jurisdiction. Sometimes there are just laws that we want to take advantage of, and so we're able to make targeted amendments and take care of things to make sure that their estate plan is still going to give them the best result possible. Um, Another question, I have a trust created 3 to 5 years ago. How often should I review and update as needed? What does it cost to have it reviewed and updated? No children, but I have horses, dogs, trucks, and trailers. How do I add my intent for those? This is a great question. My recommendation is to do an estate plan review every 3 years. The typical guidance is something like every 3 to 5 years. With my clients, we try and do a review every 3 years just to see if anything has changed. Do any of your fiduciaries, any of your agents that you have acting in different roles, do we need to update any of those? Do we need to change any of those because maybe somebody isn't the right person to act as trustee anymore? Do we need to make any updates with things like distributions? Are we redirecting things in a different way now than we were 3 years ago? Have any of the laws changed? It was a little bit more than 5 years ago now. It was about 6 years ago that the Secure Act was passed into law. And for clients who were planning for their retirement accounts with something like a trust or with something like a will that had testamentary trusts in it, the law changed and it really affected the way that retirement accounts would be handled. And so that would be something that we would want to review and want to make sure was up to snuff. That family wealth planning session that I'm offering, I'm happy to review your estate plan and tell you where you stand. And I'm happy to do that, again, complimentary as a free family wealth planning session, just to let you know where you stand. I've had clients come in before. I had a client come in one time with a trust that had been written something like 19 years ago, 19 years in the past. But he brought in this trust, and I walked him through the different provisions that he had, and I said, this is who you have listed as your trustee, is that right? And he said, yes. And I said, this is who you have receiving from your trust, is this right? And he said, yes. And I walked him through the different provisions and told him exactly what it said and how it was being handled. He had his retirement accounts going by beneficiary designation directly to specific beneficiaries instead of through his trust. In the end, there wasn't any work for me to do. And that's what I told him. I said, your plan is doing what you want it to do. So there's nothing for me to do. And he said, well, is there some way that I could hire you anyway, just so that you can be the go-to person for my family? And I said, you don't have to pay me something to do that. Here's my card. If something happens to you, have your family give me a call, and I will help them through the administration process at that point. But I really encourage you, if you haven't had your trust looked at, if you haven't had your estate plan looked at in a little while, I'm happy to do an estate plan review and just tell you where you're at. And if you're comfortable, if you're confident with where you're at, that's great. But if there are things that I can help with, I'd love to help. I will be covering how to select a trustee and fiduciaries. Here are the things that you're really looking for. Most often, fiduciaries, people like trustees or attorneys in fact under a power of attorney, or a healthcare agent under a healthcare directive, come from your family or from your friends. And what we're looking for a trustee, which is the same as what we're looking for from an executor or from somebody like an attorney in fact under a power of attorney, or sometimes we call that person an agent under a power of attorney, is somebody who's organized. We want somebody who knows how to balance the checkbook, right? Make sure that your creditors are going to get paid on time, is organized and able to do your taxes. They don't have to be an investing guru or anything like that. They can hire, or they can, put money under management at an institution that's going to handle it for them. But we want somebody who's organized. We want somebody who's going to be able to keep things straight and make sure that things are happening the way that they're supposed to happen. That's what you want from a trustee. And if that doesn't describe anybody in your family or anybody in your friend group, that's okay. There are professional fiduciaries who will handle it for you. And there are companies that are professional fiduciaries. There are also corporate trustees who would take the work on. And really the difference between the two, a corporate trustee is somebody like a bank, like US Bank or Wells Fargo Bank, whereas a professional fiduciary is a company where they do things like serve as an agent or attorney, in fact, under a power of attorney, or they serve as a trustee or executor under a trust or under a will. Um, and that's just their job. That's just what they do, is just take care of that. And typically those professional fiduciaries charge less than the corporate trustees do. Not always, but we kind of compare them, and that tends to be the case, is that we're going to have less charges with a professional fiduciary. If that sounds like a good way to move forward, if that sounds like something that you want to explore, I invite you to reach out to me and we can talk about it more. And we can talk about how we can find the right person to be your trustee, the right person to be your professional fiduciary or executor. Healthcare is a little bit different. With healthcare, it's good to have somebody who understands your desires, who understands your wishes, and is going to be an advocate and make sure that those get carried out. And it can be helpful as well if that person has some understanding or some knowledge of the healthcare industry to make sure that things that they're talking to the right decision makers in that. Another question here, can in a special needs trust, an SNT trust, pay for rent at an assisted living facility or independent apartment? Yeah, and this is a good question. It's a very specific question, and again, I invite you to reach out to me so that I can get a little bit more detail. But typically, yes. There's actually, in supplemental needs trust or special needs trust, there's typically a provision that when somebody turns 65, if they have to go into an assisted living or nursing home care facility, it typically opens up that special needs trust here in Minnesota, or that supplemental needs trust, and says now this money that was being kept separate and was being kept aside, now this money in this supplemental needs trust needs to be used for nursing home care, for assisted living care. And I'd be happy to review the document and make some further recommendations or specify information about that a little bit if that can be helpful for you. Again, I'm going to post my link to my calendar here again. And I really encourage you to go on and find some time to meet with me. I see people have taken time. It looks like in middle of February, I see people, kind of all over the place. Lots of appointments are scheduled here, and I want you to find a time that's going to work for you. So please click through that link and find some time that that you can meet with me. Even more people coming in. This is great. This is great. I'm really looking forward. I hope I get to meet with lots of you. Another question here, do you share your PowerPoint for us to review what you covered? I'm not going to share my PowerPoint, but I am going to share my the recording of this presentation here, and so you'll be able to review it. You'll be able to look at it, you could speed it up if I'm not talking fast enough, or slow it down if I've been talking too fast as well. Somebody's saying that they can't see access to the calendar. Oh, good. Okay, you were able to find it. Yep, that link. If you click through that link, you should see some options. If you click on Family Wealth Planning Session, right now it looks like there's not any availability here in January. Oh, the availability in February is starting to get somewhat sparse, but there's better availability out into March, and even better availability if you go all the way out into April as well. So hopefully you can find some time to come in and meet with me. Certainly, if it feels better to start with a 15-minute phone call, we can handle things that way too. And I'm happy to do that. I have a calendar there for 15-minute phone call times as well. I even have some time as soon as next week to do that 15-minute phone call. If you're eager to just get on the phone with me and just start the conversation, I'd be happy to do that. But really, the family wealth planning session should be your next step. I look forward to meeting with you. I look forward to helping take care of your estate planning needs. We can make this simple. Again, the 2026 checklist. This checklist for most people is a full year checklist. It's going to involve research. It's going to involve finding different documents and maybe creating some documents. It's going to be involving a lot of research and a lot of particulars. This plan is going to take 4 to 6 weeks. We're going to be able to write you an estate plan. You're going to be able to sign documents 4 to 6 weeks after our meeting, and it's going to be taken care of for you. We're going to bring you along on the process, fully empower you the entire way, all the way along. We empower our clients. We don't make decisions for them. You are an expert in your life. You are an expert in your assets and your family and the way that you want things to be. We're just going to bring the knowledge that we have about the law and about the different estate planning tools that we have to empower you to make the decisions that you want to make in order to make sure that things are taken care of in the way that you want them to be. But I really encourage you to reach out to us. I really encourage you to bring us on board, to have us be a help to you so that you can write your estate plan here in 2026. It is doable, and you don't have to carry this around on your shoulders anymore. It's time to let it go. It's time to feel comfortable, to feel confident that your loved ones are going to be cared for. Thank you, everybody, for being here with me tonight. I really appreciate it. I really have enjoyed sharing this time with you, and I hope that all of you have a great rest of your evening.